So friends, today's case is MC Mehta versus Union of India. This case was not directly argued by Nani Palkiwala, but their contribution in this case with RC Mehta is on a great scale. So Nani Palkiwala was a prominent Indian lawyer and constitutional expert renowned for his advocacy in various landmark cases. One of his significant contribution was in the case of MC Mehta versus Union of India, which is often associated with environmental law and public interest litigation in India. Overview of the case. MC Mehta, an environmentalist and lawyer, and filed a public interest litigation, that is PIL, against the Union of India and other parties regarding the environment degradation caused by the industrial pollution and the protection of the Taj Mahal, which was being threatened by air pollution from nearby industries, particularly from Mathura refinery. Nani Palkiwala's contribution. 1. Legal expertise. Palkiwala's involvement was pivotal as he was known for his eloquent advocacy and deep understanding and constitutional and environmental law. His argument helped in farming the environmental corners as constitutional issues. Because with the help of Nani Palkiwala, MC Mehta has drafted and pleaded this case in person. He was a very learned lawyer also. Second, constitutional arguments. He emphasized the fundamental right to life under Article 21 of the Indian Constitution, arguing that a healthy environment is instinct to the right to life and dignity. Palkiwala's interpretation extended the scope of Article 21 to encompass environmental protection. 3. Economic perspective. Palkiwala provided insight on the social economic implications of environmental degradation, advocating that economic development should not come at the cost of essential ecological balances. 4. Judicial influence. Supreme Court's judgment in this case, which recognized the need for environmental protection and any hitter is going on there? Sound is there? Okay. The Supreme Court judgment in the case, which recognized the need for environmental protection and duty of the state to preserve the environment for future generations, which influenced by the arguments presented by Palkiwala. 5. Border impact. The case significantly contributed to the development of environmental jurisprudence in India. It led to the establishment of the principle of the popular pays and polluter pays and set importance precedent for subsequent environmental cases and regulations in India. Palkiwala's contribution in MC Mehta has exemplified his commitment to constitution value and environmental conversation, underlying the interconnectedness of law, nature, and public welfare. His advocacy played a crucial role in shaping the legal landscape surrounding environmental issues in India. Now, I will give you the information about the that case judgment. So this case was decided in 1986, 20th December 1986. Writ petition number 12,739 of 1985. Cause title MC Mehta and others versus Union of India. This was the constitutional bench, 5 judges bench, G.L. Oza, K.N. Singh, M.M. Dutt, P.N. Bhagwati, and Rangnath Mishra. The council, MC Mehta himself is as a petitioner, party in person. And for respondent, B. Datta, Additional Solicitor General, Anil B. Dhawan, Phali Sam Nariman, B.R.L. Iyengar, and Hardev Singh, advocate. Subject Constitution. Acts involved in this case: Constitution of India, Article 12, Article 15(2), Article 17, Article 21, Article 226, Article 23, Article 24, Article 32, Article 32(1), Article 32(2), Industrial Development and Regulation Act 1951, Section 18A, Section 18AA, Section 18G, and Section 2. The cases referred in this case was Bandhua Mukti Morcha versus Union of India. This was also a landmark case. Then SP Gupta versus Union of India. People's Union for Democratic Rights and others versus Union of India. Rudul Saha versus State of Bihar. Rajasthan State Electricity Board, Jaipur versus Mohanlal and others. Sukhdev Singh and others versus Bhagat Ram and others. And so many cases are there. And authorities are referred, any foreign authorities referred here is Halsbury Laws of England, Volume 45, Para 1305. Case note of this case: Constitution, maintainability. Applications were filed by Delhi Legal Aid and Advice Board and Delhi Bar Association for award of compensation to persons who had suffered harm on account of escape of helium gas from plant of Shriram Food and Fertilizer Industries. However, as issues raised involve substantial question of laws relating to interpretation of Article 21 and 32 of the Constitution, case was referred to a larger bench of 5 judges. Hence, this appeal, whether under Article 32 applications for compensation sought could be maintainable, held under Article 32(1, court was free to divide any procedure appropriate for particular purpose for proceeding. However, power of court was not only injunctive in ambit, that is, preventing infringement of fundamental right, but was also remedial in scope and provided relief against breach of fundamental right already committed. Thus, court had power to grant such remedial relief and could include power to award compensation in appropriate cases. Hence, it was unjust to a person whose fundamental right was violated to require him to go to civil court for claiming compensation. Appeal disposed of. So compensation which demanded in this case. So there should not be football of the aggrieved people who are suffering because of the bad weather, bad environment, bad chemical effect. So no need to go to them to claim compensation in civil court. So question of law is arise whether Article 32 allows give the compensation. So answer is yes, hence it can be given. A ratio decidendi came out of this case was courts shall order authorities for enforcement of fundamental right of citizen and to protect fundamental right of people. This case category, letter petition and PIL matter. Air pollution matters, i.e. industrial, vehicular, power station, etc. What P.N. Bhagwati, Chief Justice, is mentioning here in the judgment at initiation of this judgment. One, this writ petition under Article 32 of the Constitution has come before us on a reference made by the bench of 3 judges. The reference was made because certain questions of seminal importance and high constitutional significance were raised in the course of argument when the writ petition was originally heard. The facts giving rise to the writ petition and subsequent events have been set out in some detail in the judgment given by the bench of 3 judges on 17th February 1986. And it is therefore not necessary to reiterate the same. Reiterate means to repeat it again. Reiterate, to repeat it again. So not necessary to reiterate the same. Suffice it to state that the bench of 3 judges permitted Shriram Food and Fertilizer Industries, hereinafter referred to as a Shriram, to restart its power plant as also plants for manufacture of caustic chlorine, including its byproduct, and recovery plants like soap, glycerin, and technical hard oil, subject to the conditions set out in the judgment. That would have ordinarily put an end to the main controversy raised in the writ petition, which was filed in order to obtain a direction for closure of the various units of Shriram, that Shriram is that industry, which already I have given full form, Shriram Food and Fertilizer Industries, hereinafter referred as a Shriram. Various units of Shriram on the ground that they were hazardous to the community, and the only point in dispute which would have survived would have been whether the unit of Shriram should be directed to the removed from the place where they are presently situated and relocated in another place where there would not be much human habitation, so that there would not be any real danger to the health and safety of the people. So this case is very important when such type of hazardous or which if any industry is producing some chemical fog like that, so to stop them or to eject that particular industry from that area to less human interference area. So for such type of cases, this case is very good reference. And for getting compensation also, those who are getting harmfulness because of such type of hazardous chemicals or hazardous air pollution. Next. But while the writ petition was pending, there was escape of oleum gas from one of the unit of Shriram on 4th and 6th December 1985. And applications were filed by the Delhi Legal Aid and Advice Board and the Delhi Bar Association for award of compensation to the persons who had suffered harm on account of escape of oleum gas. These applications for compensation raised a number of issues of a great constitutional importance, and bench of three judges therefore formulated the issues and asked the petitioner and those supporting him, as also Sriram, to file their uh, also support as also Sriram to file their respective written submission, so that the court could take up the hearing of these applications for compensation. When these applications for compensation came up for hearing, it was felt that since the issue raised involved substantial question of law relating to the interpretation of Article 21 and Article 32 of the Constitution, the case should be referred to a larger bench of five judges, and this is how the case has now come before us. Mr. Diwan, learned counsel appearing on behalf of the Sriram, raised a preliminary objection that court should not proceed to decide these constitutional issues, since there was no claim for compensation originally made in the writ petition, and these issues could not be raised to arise on the writ petition. Then I will take you to para number 3. The first question which required to be considered is as to what is the scope and ambit of jurisdiction of this court under Article 32, since the applications for compensation made by Delhi Legal Aid and Advice Board and Delhi Bar Association are applications sought to be maintained under that article. We have already had occasion to consider the ambit and coverage of Article 32 in Bandhu Mukti Morcha versus Union of India and others. And we wholly endorse what has been stated by one of us, namely Bhagwati Judge, as he then was in his judgment, is that case is regard to the true scope and ambit of that article. It may now be taken as well settled that Article 32 does not merely confer power on this court to issue a direction, order, or writ for enforcement of the fundamental rights, but it also lays a constitutional obligation on this court to protect the fundamental rights of the people, and for that purpose, this court has all incidental and ancillary power, including the power to force new remedies and fashion new strategies designed to enforce the fundamental rights. It is in realization of the constitutional obligation that this court has, in the post, innovated new method and strategies for the purpose of securing enforcement of the fundamental rights, particularly in the case of poor and the disadvantaged who are denied their basic human rights and to whom freedom and liberty have no meaning. Then I will take you to point number 7. We are also, para number 7, we are also of the view that this court under Article 32(1) is free to devise any procedure appropriate for the particular purpose of the proceedings, namely enforcement of fundamental right, and under Article 32(2), the court has the implicit power to issue whatever direction, order, or writ is necessary in a given case, including all incidental or ancillary power necessary to secure enforcement of the fundamental rights. The power of the court is not only injunctive in ambit, that is, preventing the infringement of a fundamental right, but it is also remedial in scope. Remedial in scope and provides relief against the breach of the fundamental rights already committed wide Bandhua Mukti Morcha case Supra. Supra means above. If the court were powerless to issue any direction, order, or writ in cases where a fundamental right has already been violated, Article 32 would be robbed of all its efficacy, because then the situation would be that a fundamental right is threatened to be violated. So how beautifully discussion and how beautifully understanding of that particular section was given. Now we will discuss about Article 21. We already discussed about Article 32. Now para 8, the next question which arises for the consideration on these applications for compensation is whether Article 21 is available against Sri Ram, which is owned by Delhi Cloth Mills Limited, a public company limited by shares, and which is engaged in an industry vital to public interest and with potential to affect the life and health of the people. The issue of availability of Article 21 against private corporation engaged in an activity which has potential to affect the life and health of the people was vehemently argued by the council for the applicants and Sri Ram. It was emphatically contended by the council for the applicants with the analogical aid of the American doctrine of the state action and functional and control test enunciated by this court in its earlier decision, that is Article 21 was available as Sri Ram was carrying on an industry which, according to the government's own declared industrial policy, was ultimately intended to be carried out by itself. But instead of the government's immediate embarking on that industry, Sri Ram was permitted to carry it on under the active control and regulation of the government. Since the government intended to ultimately carry on this industry, and the mode of carrying on the industry would vitally affected public interest, the control of government was linked to regulating that aspect of the functioning of the industry which could vitally affect public interest. Now, Article 12 is also discussed in para 9. On the other hand, Council of Sri Ram cautioned against the expanding Article 12 so as to bring within its ambit private corporations. He contended that control or regulation of the private corporations functions by the state under general statutory law, such as the Industry Development and Regulation Act 1951, is only in exercise of the police power of regulation by the state. Such a regulation does not convert the activity of the private corporation into that of the state. Now, so many cases are discussed in this. Already I have read some of them. Para number 18. It was thus be seen that This court has not permitted the corporate device to be utilized as a barrier ousting the constitutional control of the fundamental rights. Rather, the court has held it is a dangerous to exonerate corporations from the need to have constitutional conscience, and so that interpretation language permitting which makes governments agencies whatsoever their main amenable to constitutional limitations must be adopted by the court as against the alternative of permitting them to flourish as imperium in imperio. Som Prakash versus Union of India, 1981, ILLJ 79 SC. And in concluding part, I will take you, and then I will conclude summary points also of this case. Just give me a few seconds. Para 32. We could also like to point out that measures of compensation in the kind of cases referred to in the preceding paragraph must be correlated to the magnitude and capacity of the enterprise, because such compensation must have a different effect. The larger and more prospectors the enterprise, larger and more prosperous the enterprise, the greater must be the amount of compensation payable by it for the harm caused on account of the accident in the carrying on of the hazardous and inherently dangerous activity by the enterprise. So when industries is big, they should give a bigger compensation like that. Since we are not deciding the question as to whether Siram is an authority within the meaning of Article 12, so as to subjected to the discipline of the fundamental right under Article 21. We do not think it would be justified in setting up a special machinery for investigation of the claims for compensation made by those who allege that they have been the victims of the oil gas escape. But we could direct that Delhi Legal Aid and Advice Board to take up the causes of all those who claim to have suffered on account of oil gas, and to file action on their behalf in the appropriate court for claiming compensation against Srinam. Such action claiming compensation may be filed by the Legal Aid and Advice Board within 2 months from today, and the Delhi administration is directed to provide the necessary funds to Delhi Legal Aid and Advice Board for the purpose of filing the prosecuting such actions. The High Court will nominate one or more judges as may be necessary for the purpose of trying such actions, so that they may be expeditiously disposed of. So far as the issue of relocation and other issues are concerned, the writ petition will come up for hearing on 3rd February 1987. So this was the matter. Now I will conclude with summary points. The case of MC Mehta versus Union of India 1986 is a landmark judgment by the Supreme Court of India concerning environmental law and right to healthy environment. Here are the key points regarding the case. Background: the case arose from the petition filed by the environmentalist MC Mehta concerning air and water pollution caused by industries around the Taj Mahal in Agra. Petitioner MC Mehta, an advocate and environmentalist, filed a public interest litigation highlighting the degradation of the environment and its impact on the Taj Mahal UNESCO World Heritage Site. Respondent, the Union of India, as well as various state governments, were respondents in the case due to their failure to curb industrial pollution. Issues involved: the primary issues included air and water pollution due to industrial waste, the right to clean environmental as a fundamental right under Article 21 of the Indian Constitution. Supreme Court's interpretation. The Supreme Court interpreted Article 21 of the Constitution, which guarantees the right to life, to include the right to healthy environment. Judgment: the Supreme Court ordered that industries in the vicinity of Taj Mahal must reduce their pollution level. The government was required to take strengthened action against the industries caused pollution. Continuous monitoring of the pollution level should be established. 7. Environmental impact assessment. The judgment emphasized the need for environmental impact assessment, EIA, environmental impact assessment, EIA, for projects affecting the environment. 8. Importance of public interest litigation. This case is significant as it expanded the scope of PIL, enabling the courts to address issues of public interest, especially concerning environmental protection. 9. Precedent for future cases. This case set a precedent in Indian jurisprudence regarding the protection of the environment and right of citizen, influencing subsequent cases related to environmental law. And 10. Significance. The ruling highlighted the judiciary's role in protecting the environment and underscored the importance of balancing environment and environmental conversation. The MC Mehta versus Union of India case remained a cornerstone in the evolution of environmental jurisprudence in India, establishing vital principle around the right to healthy environment. So, friend, this is from my side. So, today's today's case was thus we have completed, and we'll see you very soon in our next part. This is part 5, no? Yes. This is part 5. Next part 6 and part 7. So 2 parts are balanced, and then 8 is our main function, that is in auditorium. That is the Jayanti of Nani Palkiwala. Okay. Thank you. Thank you very much.
नमस्कार, मैं पूजा राय आपको एडवोकेट जयप्रकाश सोमानी जी का थोड़ा सा परिचय करके देती हूँ। जयप्रकाश बंसीलाल सोमानी सर्वोच्च न्यायालय में अधिवक्ता हैं। 12 जूनियर के साथ वो लॉ फर्म चलाते हैं, जिसमें 5 AOR हैं। सोमानी जी भारत के हर राज्य और केंद्र शासित प्रदेश के मैटर बखूबी हैंडल करते हैं। सुप्रीम कोर्ट केस लॉ के ऊपर उनकी 61 किताबें प्रकाशित हुई हैं, जो Amazon और Flipkart पे अवेलेबल हैं। लिंक आपको नीचे डिस्क्रिप्शन में मिल जाएगा। भारत के लगभग सभी हाई कोर्ट और डिस्ट्रिक्ट कोर्ट के अधिवक्ता इन किताबों का उपयोग करते हैं। अगर आपको सोमानी जी की गाइडेंस अच्छी लगती है तो नीचे कमेंट बॉक्स में जरूर लिखें और अपने दोस्तों के साथ शेयर करना ना भूलें। हाँ, अगर आपने चैनल को सब्सक्राइब नहीं किया है तो सब्सक्राइब कर लें और बेल आइकन को दबाना ना भूलें, ताकि हमारा कोई भी नया वीडियो आता है उसका अपडेट आपको मिल सके। जय हिंद।